tax dispute resolution division has evolved over time, and currently it is having two divisions. It is having the independent review of objections and the alternative dispute resolution. It was created by a legal notice number 12048, volume CXX number 14 of 11th November 2018 for objections under section 51 of the Tax Procedure Act, and also legal notice number 1036, volume CXX1 number 14 of 1st February 2019 for objections under East African Customs Management Act, which is the customs objections. A tax dispute arises from assessments which are made by the commissioner from tax decisions. Any tax decision that a commissioner makes, including objections, decisions, and reliefs which have not been given. A taxpayer can object after 30 days when a decision is issued by the commissioner. The commissioner has three options when making an objection decision. He can fully accept the objection, therefore agree with the taxpayer, and there is no tax to be paid. He can partially agree with the taxpayer and therefore amend the assessment according to his findings. He can also completely disagree or reject the objection, and therefore he confirms the assessment. The commissioner issues an objection decision within 60 days, but if he requests for more information from the taxpayer, he can exceed that period. For customs cases, he takes 30 days unless he asks for more information from the taxpayer. If the commissioner does not issue an objection decision within 60 days for DTD cases and within 30 days for customs cases, the objection is allowed. IRO stands for Independent Review of Objections. It is a unit within the Tax Dispute Resolution Division, and its mandate is to review all the objections within the Domestic Taxes Department and also the Customs Department. Independent review of objections decision is final, but the taxpayer is allowed to appeal to the Tax Appeal Tribunal or to the courts. If the taxpayer is not comfortable with the decision issued by independent review of objections, he can appeal to the Tax Appeal Tribunal or he can appeal to the courts. Yes, there is another way in which a taxpayer can resolve his tax dispute through the alternative dispute resolution mechanism. ADR means alternative dispute resolution. Is an efficient and faster way of resolving tax disputes without any costs. The legal framework of ADR is found in the Constitution of Kenya, Article 159, 2C, and also Section 55 of the Tax Procedure Act, and also Section 28 of the Tax Appeal Tribunal Act. A settlement may not be allowed under ADR if the request has a criminal connotation. Also, it may not be allowed if the taxpayer withdraws or the commissioner withdraws from the matter. It may also may not be allowed if the issue has already been decided by the courts or by the Tax Appeal Tribunal, or the case has interpretation issues. So such cases are forwarded to the Tax Appeal Tribunal or to the courts to be dealt with. The ADR process starts with the application for the tax issue to be resolved by the alternative dispute resolution. The commissioner can apply and the taxpayer can apply. Then the commissioner checks whether the case is amenable by requesting from the independent review of objections or from the commissioner whether they are amenable for the case to be heard at the alternative dispute resolution. The case is heard by the alternative dispute resolution and it is resolved, and when it is resolved, an agreement is made on how the case is going to be resolved, and the case is concluded and a report is given to the court or even to the Tax Appeals Tribunal. The alternative dispute resolution covers the income tax, VAT, excise, and also customs cases. The parties are the commissioner and also the taxpayer. Anyone, the taxpayer or the commissioner, can apply for ADR. The Tax Dispute Resolution Division is found in Upper Hill, Ushuru Pension Towers, Block B, on the 7th floor.